Good evening, everyone, and welcome to our final debate of the semester. This series was named in honor of Daniel Webster, as I'm sure most of you already realized, one of our nation's greatest orators, public servants, and advocates. Founded just last year, the series has already become the heartbeat of our chapter and a cornerstone of the intellectual conversation here in the nation's capital. By bringing together leading judges, scholars, and practitioners from across the country, we aim to engage the most pressing legal and policy issues of our time. Tonight's resolution, should the court abandon substantive due process, addresses perhaps the court's most controversial doctrine, from which the court derives much of its fundamental rights, including parental rights, the right to same-sex marriage, and of course, for 50 years, the right to obtain an abortion. Many scholars have questioned the perceived paradox of substantive due process, and Justice Thomas, for one, has been open to revisiting more of the court's substantive due process cases beyond just Roe itself. However, just this week, the court refused to do so in a case that asked whether Obergefell and the quote-unquote legal fiction of substantive due process should be overturned. So to explore this ever-relevant and rich issue, it is therefore my honor to host this evening's program featuring two of the nation's leading experts on the issue, and to welcome our very own Professor Irving Gornstein, Director of Georgetown's renowned Supreme Court Institute, as tonight's moderator. So without further ado, please join me in welcoming our Director of Debates, Louis Fong, who will formally introduce our three distinguished panelists. Thank you so much, everyone.
Thank you, everyone, for coming tonight. Professor Irving Gornstein is the Executive Director of the Supreme Court Institute and a Professor of Practice at Georgetown Law. He worked in the Department of Justice, first in the Appellate Section of the Civil Rights Division, and then at the Solicitor General's Office. He has argued 38 cases in the Supreme Court and more than 30 cases in the Court of Appeals. On the affirmative is Brent Skorup, who is a legal fellow in the Cato Institute's Robert A. Levy Center for Constitutional Studies. Before joining Cato, he was a senior research fellow at the Riccata Center at George Mason University. His research areas include free speech, technology law, Fourth Amendment protections, regulation, and property law. The Pennsylvania Supreme Court and a dissenting opinion in the Illinois Supreme Court have cited his legal research. He has a BA in economics from Wheaton College and a law degree from George Mason University School of Law. On the negative is Chance Weldon. Chance is a senior attorney and director of litigation for the Center for the American Future at the Texas Public Policy Foundation. Since joining the foundation, he has worked on some of its most important cases, from protecting the rights of property owners along the Red River in northern Texas, to striking down the City of Austin short-term rental regulations. He has been at the forefront of protecting constitutional rights in Texas and across the country. He received his JD from the University of Houston and received his BA in philosophy from the University of Houston as well. And a note about the Federalist Society. The Federalist Society is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is and not what it should be. And with that, I welcome tonight's debate.
All right, so it's a pleasure to be here. This is my first time, and I hope I'll have other occasions to be here as well. So let me give a brief introduction to what you're about to hear before we get into the people who are going to take sides on the issue. I'm going to try to play it straight ahead, give you the background. So the 14th Amendment provides that no state shall deprive any person of life, liberty, or property without due process of law. There's never been any doubt that the amendment guarantees that deprivations of life, liberty, or property must be accompanied by procedural protections, such as notice and an opportunity to be heard. The question our program will address tonight is whether the amendment also contains a substantive component, known as substantive due process, that protects certain liberty interests against state deprivation, no matter how much process is provided. The court first applied substantive due process in the Dred Scott case, which held that congressional legislation restricting the institution of slavery violated the substantive rights of slaveholders. It later applied the doctrine in a series of 20th century cases, including Lochner versus New York, that invalidated a large number of health, safety, and economic regulations on the grounds that they unreasonably interfered with the freedom of contract. Neither Dred Scott nor the Lochner line of cases has survived, the former overruled by the Civil War amendments, the latter by the court itself. But the court the court has nonetheless continued to hold that the 14th Amendment protects certain substantive rights. The court has protected two categories of substantive rights. The first consists of most of the rights guaranteed by the first 8 amendments to the Constitution, which originally only applied to the federal government. The second, and far more controversial, consists of unenumerated rights that have been deemed fundamental. Among the rights recognized as fundamental today are, as you have heard, the right of parents to direct the education of their children, and in addition, the right not to be sterilized, the right to marry, the right to use contraception. The most controversial of the substantive due process decisions, of course, was Roe against Wade, which recognized the right to terminate pregnancy through an abortion. Roe sparked a backlash against substantive due process in an effort to rein it in. The key case limiting the reach of substantive due process is called Washington against Webster. It imposed 2 limits. First, the right must be deeply rooted in the nation's history and traditions and implicit in the concept of ordered liberty. And second, there must be a careful description of the right, which actually means that a historic right must be described at the most specific level. Glucksberg also reaffirmed 2 substantive due process standards of review. For fundamental rights, a state must show that an infringement is narrowly tailored to further a compelling interest. For other liberty interests, an infringement is constitutional if rationally related to a legitimate state end. 2 subsequent cases deviated from Glucksberg. Lawrence versus Texas invalidated a law prohibiting intimate sexual relations between 2 persons of the same sex, reasoning that history and tradition are the starting point but not the end point in substantive due process cases. Obergefell held that the already recognized right to marry extended to persons of the same sex, even though the historic right to marry did not. That brings us to the court's decision in Dobbs. Relying on the Glucksberg method of analysis, the court held that history and tradition did not support the claim that there was a right to terminate pregnancy through an abortion. Then, applying the stare decisis factors, the court concluded that Roe must be overruled. While it is unclear whether any of the rights previously recognized as fundamental could survive under a Glucksberg analysis, the court made clear that its decision did not affect any of those rights. The distinction, the court said, is that abortion, unlike other recognized rights, destroys what the court's decisions called a potential right. In his concurring opinion, as we've heard, Justice Thomas called for a wholesale reevaluation of all substantive due process decisions. The due process clause, he says, at most guarantees process, either the process required by legislative enactments and the common law, or the customary process to which free persons were entitled by the old law of England. For Justice Thomas, substantive due process is an oxymoron. The notion that a provision that guarantees only process before a person is deprived of life, liberty, or property could define the substance of those rights, he says, strains credibility for even the most casual user of words. He therefore stands ready to overrule every one of the substantive due process cases, including the 3 most famous, Griswold, Lawrence, and Obergefell. After overruling all substantive due process cases, though, Justice Thomas would then consider whether any of the rights recognized in those cases is protected by the 14th Amendment's Privileges and Immunities Clause. With that, I turn the program over to our 2 advocates to address tonight's question, should the court abandon substantive due process? And Brent, you're up first.
Thank you, and good evening. And I realize I might be taking an unpopular position. I'll be arguing in the affirmative, and it's probably a long shot, but I'm a Cubs fan. I'm accustomed to long shots, so here it goes. I would affirm the motion the Supreme Court should abandon substantive due process. And I'll also will answer with my time an obvious objection which is how do you protect unenumerated fundamental rights. And I would say that the Supreme Court should revive, as Justice Thomas has suggested, the privileges or immunities clause of the 14th Amendment to ascertain those fundamental rights. I'll start by saying due process, the phrase in the clause, is a thin reed on which to hang fundamental rights. Let's look at the text. The state shall not deprive any person of life, liberty, or property without due process of law. A plain reading of this indicates this is about due process. This is about the process you are due. And I confess, in law school, I was very confused trying to understand what substantive due process meant, how it operated, how it evolved over time. I was somewhat relieved years later to find that many constitutional scholars, no less than John R. Ely, as he said, it's a contradiction in terms. Substantive due process is a contradiction in terms, sort of like green pastel redness. And I would say that's a slight caricature. Certainly due process has some substantive elements, meaningful notice, opportunity to be heard, a neutral adjudicator. These are not pure procedure. There is important substance in those. And I would add there's been important scholarship by Randy Barnett and Kurt Lash and others who pointed out that there is a fair amount of substance that probably comes with this due process phrase. It probably is a term of art that has more to it than mere process. But even if we accept that strong argument, that it's still a tenuous and contested way to interpret due process. And ultimately that brings me to my second point, that the proof is in the pudding. Substantive due process is a doctrine in chaos. Lochner, Roe v. Wade, Dobbs, whatever your politics, you probably have a strong negative reaction to some of those cases. Yet in each of those cases, the court believed they were faithfully applying substantive due process. That's a problem. It signals that substantive due process has whipsawed over generations as the composition of the court has changed in unpredictable ways. It's damaged the legitimacy of the court, as it's hard to ascertain how you evaluate and protect fundamental rights. The doctrine itself has somewhat dubious origins in the Gilded Age, the so-called Lochner era. In the 1880s and 1890s, primarily it was railroads, utilities, and insurance companies who were bringing these due process arguments that their liberty rights were infringed by state regulation that regulated their rates. I'm a libertarian. You don't need to do much to convince me that regulators can be heavy-handed, they can violate rights, they can violate due process rights. But to paraphrase Alan Gura, the Civil War, the Reconstruction, and the 14th Amendment were not about the profits of utilities and corporations. They're about protecting the rights of all Americans, and especially the former slaves, the individual rights. Due process ultimately could not bear the weight of unenumerated economic rights, and the Supreme Court abandoned that approach in Parrish in 1937. And there, substantive due process lay dormant for decades. A huge stigma. Even in Griswold, the majority couldn't bring themselves to say the word substantive due process. But in the 60s and 70s, it was revived and repurposed for social issues, and most famously in Roe v. Wade, to protect the right to an abortion. But as we know, Roe v. Wade did not settle the issue. It was contested from the beginning. A huge amount of Americans never accepted the analysis, never accepted the court's method for analyzing fundamental rights. It roiled politics for decades, and it ultimately collapsed under the weight of its own reasoning. And Dobbs was a capstone, overruling the most significant substantive due process case, and on the flip side, generating a big backlash because of what Dobbs represented. So it's clear, substantive due process for a century has been on shifting sands. It's simply not sustainable. And so finally, I'll argue the Supreme Court, as an alternative to defend and protect unenumerated rights, should look and revive the privileges or immunities clause of the 14th Amendment. It's been largely ignored since the Slaughterhouse case in 1873, where the Supreme Court said it means little more than a few narrow national rights like the right to access a seaport or federal buildings, and that sort of thing. As Robert Bork said, Slaughterhouse essentially made the Privileges and Immunities Clause an ink blot on the Constitution. If you open it up, it's unreadable. It's essentially redacted out of the Constitution. And that's a problem of itself, particularly when you consider the 14th Amendment was intended to allow or ratify the rights recognized in the Civil Rights Act of 1866. I would also add another legacy of substantive due process is to relegate economic liberty. I mean, the stigma of the Lockman era. In Parrish, the Supreme Court relegated economic liberty to a second-class right that subject to rational basis in most cases, which would be a surprise to the drafters of the 14th Amendment, who were insistent on protecting the rights of all Americans, but particularly former slaves, so that they could, so that the right to contract were protected, the right to own property, bequeath property, own homes, do the occupation of their choice at a time when many southern cities required former slaves to only work in menial jobs. Privileges or Immunities Clause is not an empty vessel. Certainly, it's in its dormancy for 150 years, it's underdeveloped, but it would allow the court to sever the tie, escape the baggage of substantive due process, and found it on stronger texts within the 14th Amendment. So I'll conclude by saying substantive due process, it's a wounded doctrine, its textual support is weak, and it's led to doctrinal chaos. It's harmed the court's legitimacy, and it's time to let it go.
Yes.
Well, I disagree. That's the point of the debate,
I
right?
thought you were just going to say everything you said. It just makes so much sense.
So I think I'd like to start by saying what I'm not defending here today. I'm not going to make an argument in defense of a substantive due process that would say, for example, uphold Roe versus Wade. I think even under a robust originalist view of substantive due process, that opinion is probably wrong-headed. In fact, it's definitely wrong-headed, and we don't need to get into that here today, though I can do that in Q&A if anyone's curious. I'm also not going to talk about incorporating the Bill of Rights. I think as a matter of original public meaning, the clearest path to incorporation of the Bill of Rights is the Privileges or Immunities Clause. As a matter of fact, if you read John Bingham, who is largely responsible for drafting the Privileges or Immunities Clause, when he introduced the 14th Amendment onto the floor of the House, he introduced it as an amendment to incorporate the Bill of Rights against the states. And yet we've spent generations now arguing about selective incorporation. That's not what I'm arguing substantive due process here today. Instead, I think what I'm arguing is far more narrow, which is, does the Due Process Clause, as originally understood at the time of ratification, place any substantive limitation on the legislative power, or is it merely procedural? And like a good litigator, I think I'd like to talk about a few cases. And as an originalist, I'd like to talk about the cases that are closest to the ratification of the 14th Amendment. I'd like to start today with a case called Yates versus Milwaukee. You've probably never heard of it, right? Who here has read Yates? Thank you for being as nerdy about property rights as me. I appreciate that. I feel seen. So Yates versus Milwaukee is decided 3 years after the ratification of the 14th Amendment, and it's about an ordinance that restricted the location of docks on private property. And the city in that case argued that the docks, of course, would be an obstruction or a nuisance, and therefore within their police power they could prohibit private property owners from constructing them. This is sort of like a proto-zoning ordinance. And what the Supreme Court said is, well, at the common law, you had the right as a riparian owner to construct docks. This is a private property right. The record in the case produced by the city doesn't show that these docks are actual obstructions or nuisances. And therefore, by restricting it through an ordinance, through legislation, you've deprived them of property without due process of law. So apparently the court in 1871 didn't think it was so stupid, as Justice Thomas would point out, to think that due process of law provided a substantive limitation on the legislative power. That same year, the Wisconsin Supreme Court struck down a local ordinance restricting the sale of lemonade as exceeding the police power. Now, by the way, if you really want to read a case with some interesting facts, read this case. Someone gets hit in the head with a pitcher, the cops chase the guy around. The facts are a lot of fun. But the important point of this case is interpreting their own state constitution in 1871, the Wisconsin Supreme Court likewise held that a restriction on the right to earn a living, a restriction on the right to sell lemonade was unconstitutional because it wasn't within the police power. And neither of these cases made a blip at the time. That's why you've never heard of them. They weren't controversial. And the reason they weren't controversial is because by 1868, a majority of state courts around the country had interpreted their due process and due course of law provisions of their state constitutions to place substantive limits, judicially enforceable limits, on the legislative power. As early as 1833, Joseph Story wrote that it was the majority opinion at the time of state jurists that there were inherent, implicit, judicially enforceable limitations on the legislative power, that the police power itself was not unlimited. Going back even further, if we want to go back even further to closer to the founding, in 1815, Chancellor Kent, sitting in the Court of Chancery, struck down a statute that would have transferred private property from one person to another without compensation. And now what's interesting about that is at the time, New York did not have a takings clause. It did not have a takings clause. All it had was a due process of law clause, and that's what he struck it down under, because he says the legislature does not have the inherent authority to transfer property from A to B without compensation. Similar property rights decisions came out in Pennsylvania in 1843, in Georgia in 1847, in New York in 1856, in North Carolina in 1859. One of my favorites is from Tennessee. It's Mayor B. Winfield from Tennessee in 1848. And there the Supreme Court in antebellum Tennessee struck down a local restriction, a local ordinance that said a curfew for freed black men. The idea being that individuals have the right to move about unless there's something within the police power, unless you can show that the exercise of this right is harmful to one's neighbors. And since there was no evidence in the record to show that, that ordinance was struck down in antebellum Tennessee in 1848. So what were these courts doing? Clearly they were reading the due process clauses of their state constitutions differently. They were reading this term of art differently than Justice Scalia and Justice Thomas and Judge Bork. They clearly didn't think that this legal term of art, which has its origins in Magna Carta, was limited to procedure only. And that's because they were reading the entire text of the amendment. It doesn't say due process of whatever the legislature adopts. It says due process of law. And in many of the state constitutions at the time, it said the due process of the law of the land. And going back to 1795, there are cases which say that simply because the legislature, there's an act of the legislature that's adopted, that act of the legislature is not law. If it's contrary to certain natural rights, certain natural limitations on government power. This starts in 1798. You see this in Calder versus Bull. In Calder versus Bull, Justice Chase argues that an act of the legislature, for I cannot call it a law, contrary to the principles of the social compact, would not be the law of the land. Because they didn't believe that the legislative power was unlimited. They thought there were inherent substantive limitations on the legislative power, and courts had the ability to say that an act of the legislature or an act of the city council had exceeded those limits based on the record before them, and therefore was not a law, and therefore depriving someone of individual liberty or private property rights. Because of that law, because of that act of the legislature, was not due process of capital L law, or was not the due course of the law of the land. And you see these cases over and over again at the time. And that's what this, and to take it to a broader point on it, 1795, 3 years earlier, in a case called Van Horn-Sleesey versus Dorrance, Justice Patterson writes, Supreme Court, Justice Patterson writes, that the great distinction between state legislatures in the United States and Parliament is that unlike Parliament, state legislatures do not have unlimited authority. He says the powers of the state legislature are written down with precision. and they're judicially enforceable. Now, what's interesting about that is in 1795, several states did not have bills of rights in their state constitution. So what are these judicially enforceable limits? It's an enumerated powers approach to the legislative power of the state. Just as a federal court has authority to look at an act of the United States Congress and say that it's not a proper exercise of enumerated power, say, for example, the Commerce Clause, state jurists at the time believed that they had the authority to look at a legislative enactment or an ordinance or a local enactment and say that it exceeded the police power. And this was the straightforward application of state due process clauses for generations before the 14th Amendment was ratified. And so it shouldn't be strange that this would be the interpretation that was adopted just 3 years after the 14th Amendment was ratified. So what do we have on the other side, very briefly? I don't know, how am I doing on time? Good?
2 minutes.
So what are the arguments on the other side? Well, we heard today that due process, doing it is hard. People disagree about what the rights may be. People disagree about what the right outcome is. People get due process wrong. We got Roe versus Wade, which I think, of course, was wrongly decided. But people got the Second Amendment wrong for a really long time, and that doesn't mean that we throw it out of the Constitution. Judges, legal scholars can disagree on things. Originalism is not a guarantee of an answer. It's a process of arriving at a solution. It's a rigorous process of arriving at a solution. And here, the process that you would do is you would look. You would do the hard work of looking to see if this was a right that was ordinarily protected, looking to see if the evidence in the record supports the city's claim or the state's claim that it's serving a legitimate interest within the police power. And judges would, at the end of the day, have to judge, hence the title. That's what judges are supposed to do. And we understand that they can do this. The Fourth Amendment, for example, talks about unreasonable seizures. We expect judges to determine what reasonableness is. The Eighth Amendment talks about excessive fines. That's a capacious term. But we expect good originalist judges to determine what excessive is. And there's nothing different about determining whether or not something exceeds the scope of the legislative power as it would have been understood in 1868. And that's what originalism demands. And so, no, we shouldn't do away with substantive due process any more than we should do away with any other provision that's within the text of the Constitution. Thank you.
Rebuttal, right?
Yep.
Yeah, just briefly, a couple points that came to mind. One is, there, as I acknowledged, there is a strong view of due process that there is a lot of substance that might come with it if you read the debates about drafting the Constitution and then of the 14th Amendment. There is something to this idea that that it might mean something like law of the land. In my mind, that doesn't help much. That simply begs the question of what is the law of the land, and my counterpart, has argued courts need to do the hard work about interpreting what the law of the land is, what due process actually means. We've been doing it for 150 years, and it's not pretty. It's still chaotic. So I don't think doing the hard work can get us there. And so I'm willing to concede, for the sake of argument, the strong view of due process. And I think just pragmatically, when you look at it, it's led to doctrinal confusion and has earned the distrust of the right and left as the court has whipsawed over time. I would also point just textually, what the modern and even the Lochner era substantive due process interpretation has done has essentially written privileges or immunities out of the Constitution. And whenever your interpretation writes a major, highly contested line out of the Constitution, you've got to ask yourself if you're interpreting that clause correctly. And then I'll leave it there. Thank you.
Rebuttal?
I don't think that it has to read the Privileges or Immunities Clause out of the Constitution. I think there's a little bit of belt and suspenders going on, but there are different provisions. The Privileges or Immunities Clause places clear jurisdictional limitations on what the legislature can do. The Due Process Clause, it sets a floor about certain things about enforcing the police power limitations and making sure things are traditionally within the legislative power. And there's a reason that was done. The Privileges or Immunities Clause only applies to citizens. And the Due Process Clause applies to all persons. Right? So you're going to have base level protections where the state can't deprive anyone, citizen or otherwise, of certain rights unless there's a legitimate government interest based in the record. And there are other things that are privileges or immunities of citizens, which the legislature just at post 14th Amendment doesn't get to prohibit at all. And so those lists may be different, but I think there's room for both of those things. There's room for both of those things to exist simultaneously. I don't think I've ever heard a argument that because the court screwed up the Privileges or Immunities Clause, it should also screw up the Due Process Clause. And I think that we should get both of them right. And so I guess that would be my rebuttal.
Thank you. So let me start with a question for Brent. If you sounds to me like you want to move over protection for fundamental rights to the Privileges and Immunities Clause, is there then anything left that would protect non-citizens, or are they just out of luck when it comes to having any substantive rights under our Constitution? For example, could they be subjected to torture under our Constitution, to cruel and unusual punishment, to forced sterilization?
In short, no, I don't think so. Yeah, I will concede this area of law is underdeveloped. But I would concede due process probably means something substantive at some level. The law of the land. I would also say equal protection protects all persons, and there's I think equal protection does allow the word as well.
Okay. Anything you want to respond to on that question, or do you want to leave that one alone?
No, I think that's a great question. That would be the question that I would ask. Yeah.
So for you, let me start with this question. As I understand originalism, at least as a starting point, you look at what the reasonably well-formed, informed person of the day, how they would understand the language. Yeah. And it seems to me the courts you're relying on are going by something other than what the reasonably well-informed person would have understood these words to mean. As Justice Thomas says, at least for me, when I heard the word due process, I'm thinking of law, that it's the procedures by which the law is enforced. Now you say law, and if something is not sort of reasonably related to a legitimate public end, that's not a law. I think the reasonably informed observer who heard what you just said would say, that's a law that is not reasonably related to a legitimate public end. They wouldn't say, that's not a law at all. So what's your response to that?
I think that's correct in the 21st century. I think that we've had a lot of legal positivism that's been taught to us. I think that would not have been true in 1868, where the average person still believed in the natural law, when the average person still believed that there was an inherent tie between the positive law and the natural law. And I don't think it's true in a country that at the time of the American founding, the two most common books were read in the colonies were the King James Bible and Blackstone's commentaries on the laws of England. Like, people were pretty nerdy if they could read. And so if you're talking about the reasonably informed reader at the time, they would have understanding about what the law of the land clause meant. They would have a basic understanding that, as was pointed out by the Supreme Court in 1798, that an act of the legislature contrary to the first principles of the social compact is no law, right? In McCulloch versus Maryland, Justice Marshall pointed out that if the government exercises authority not granted, that it is not the law of the land. The act of the legislature would not be the law of the land. So by the time you get to the radical Republicans, in 1868 that are drafting and preaching for the 14th Amendment, it was understood that there were certain acts of the legislature that were not in fact laws. And I think to your point, I think we don't have that today, but that's not what we're looking at as originalists.
All right. So question 2 for you is in terms of whether you put this underneath the substantive as a matter of substantive due process, you protect certain fundamental rights, or you put them under the Privileges and Immunities Clause. Does it matter to you which one it's under in terms of how you figure out if it's protected or not? Is it the same methodology that you would use to determine whether that the court currently uses under Glucksberg to determine whether there's a substantive due process right? Would you just move over all of that into the Privileges and Immunities Clause, or is there some difference that occurs in figuring out what rights are protected once you move things over to the Privileges and Immunities Clause?
So I'm not the first to make this point that if you were to transplant or revive the Privileges or Immunities Clause, it would probably end up looking much like what the court has done more recently with substantive due process, and particularly the Glucksberg test. I think Glucksberg would quite naturally work pretty seamlessly with the Privileges or Immunities Clause. I would add one benefit, as I see it. Now, I haven't seen him put it exactly this way, but Michael McConnell has pointed out that for Glucksberg, you should probably also look at consensus, whether there's consensus on an unenumerated or fundamental right. I think the Privileges or Immunities Clause does that better than the due process. Privileges or immunities recognized by states, I think, almost invites courts to look at what are states doing and see if there's consensus on this thing. I think that would help a lot. I think it would. I looked this up. Griswold, for instance. Connecticut was the only state that had a law that did not allow contraceptives for married couples. I think under my test, if you have Glucksberg plus a kind of consensus or look at state law test, Griswold comes out the same way, just I think on stronger terms. Lawrence and Bergefell similarly. It's a minority of states in each case, and I think if you have Glucksberg plus this consensus provision, which is, I would say, look at what state law is and see if there's consensus, I think that gets you a lot of the way and a lot of things the rights we would like to recognize. I think there was something else I want to say, but it's not going to mind, but I'll leave it there.
All right. Can I ask just a clarifying question on that? Is that consensus in 1868, or is that consensus right now?
I would say consensus now. Privileges or immunities, states modify, privileges, in statutory terms regularly. Privileges change, immunities change, and to me that gives some flexibility if you're interpreting what that means.
That seems to me like living constitutionalism from the right, that the rights evolve and change over time by majority vote in the states. That would be a very poor protector of individual rights in 1868 as the southern states come back in and want to oppress the newly freed slaves and the carpetbaggers and everyone else who had come down. I think that looking at consensus across the state would be a pretty perilous protector of individual rights that I don't think John Bingham or the other radical Republicans who fought so hard to get the 14th Amendment ratified would have thought counts as a privileges or immunities analysis.
I mean, you might be right in one respect, but that's not unique to Privileges or Immunities Clause. Of course, substantive due process did not rescue bigotry. And I would add, I don't think it would help Susan B. Anthony when she tried to vote, but she made a Privileges or Immunities Clause argument that was rejected because of the Slaughterhouse case. It was another constitutional argument she could make. I don't know if Plessy v. Ferguson would come out differently, but it would have provided him another argument to make, and I think a stronger one. But yeah, no, I don't, it's true, but I don't think that's unique to privileges or immunity clause.
So maybe I'll jump to a question that I've already kind of hinted at, but I'd like to get both of your views on, which is whether you place the substantive right inquiry under the due process clause or the privileges and immunities clause, you're still going to have to decide whether to apply the Glucksberg test to all the substantive rights that have been recognized. And if you do, I think, unless you have this consensus atom, let's put that to one side, modern consensus atom, I don't think we have a right to unwanted sterilization. I don't think we have a right to interracial marriage. I don't think we have a right to contraception. I don't think we have a right to same-sex intimacy. And I don't think we have a right to same-sex marriage if what we're looking is the Glucksberg history and tradition test as of 1866. Now, am I wrong about that, or would you basically concede that? And at the same time, what we would be doing is getting rid of all the modern rights that people recognize and replacing them with the ones the Supreme Court rejected when it overruled Lochner. And that's really, whether you put that in under the Due Process Clause or you put that in under the Privileges and Immunities Clause, when you spin it out under Glucksberg, isn't that where you end up?
I don't think so. I mean, I would be hesitant to just adopt Glucksberg's whole cloth. I think that even if you're looking at the Privileges or Immunities Clause, I think you just apply the ordinary canons of construction to privileges or immunities and figure out what that term would have been understood to mean at the time, rather than treating Glucksberg, the Glucksberg test, as if it's the Constitution itself. So I think you just go and try and figure out what that phrase would have entailed. I think that, for example, the right to marry, right? Like the right to marry, there's pretty good treatises on that being included within the scope of fundamental natural rights going back millennia upon millennia. Now, if you're discriminating on the basis of race and who gets to marry, I think you can make an originalist argument that loving was rightly decided. I think you could make, for example, I think you have a harder time with some of the other...
Just to interject, is that under the Equal Protection Clause, or is that as a matter of either substantive due process or privileges and immunities?
I think that you could do it under substantive due process or privileges or immunities, and the reason why is because the level of abstraction that you're looking at the right. Because the question is not whether or not someone who adopted the 14th Amendment would have been comfortable with interracial marriage. The question is whether or not they would have understood the right to marry to be a fundamental right, and whether or not the distinction drawn between races in that case would have been deemed arbitrary and within the police power. Because it's certainly a restriction on the right to marry. And then the only question is that restriction rationally related to something within the police power?
So, let me just interject that at least my understanding of Glucksberg is it tells you have to define the right at the most specific level. And if you define it at the most specific level, it is not the right to marry. It's the right to marry a person of the same race and of the opposite sex. That was the right that was recognized at the most specific level. Now, you can always raise the level of generality up to the right to marry, and you can go all the way up to the right to marry any person of any race and any sex, or you could even go up to the right to marry as many people as you want, not just one person. But if you follow Glucksberg, it seems to me you're stuck with the right to marry a person of the same race, of the opposite sex, and it's just one person.
Well, I'll push back on that. That's one of the reasons that I don't adopt Glucksberg whole cloth, because I think that level of generality problem is a problem. We see that in our litigation, for example, like if you're having a restriction on short-term rentals. And we would say, well, that's a restriction on the right to lease. And therefore the question is that restriction on the right to lease rationally related to a legitimate government interest? And the government comes in and say, no, it's a restriction on the right to lease for less than 7 days on a Tuesday if you have 5 people. And that is not the way the people who wrote the 14th Amendment thought that liberty was parsed up. That just doesn't work as an interpretive framework. Instead, you look at, okay, broadly speaking, you have a right to lease or you have a right to marry, and then you look at the way that the state's trying to restrict it. Now, at some point, you run into the problem that you're actually redefining what a marriage is. And that gets complicated. That's a whole much longer conversation. But if the right to marry, if marriage is a thing that's protected at the common law, which it was, then that right is protected for people regardless of race, because racial distinctions are inherently arbitrary.
So let me just get your view on this, and let me just, instead of just focusing on the right to marry, my postulate that the right to interracial marriage would have to go and the right to same-sex marriage would have to go if you apply, put that to one side and just focus on the right to contraception, the right to unwanted, not to be forced to sterilize. I don't think either of those were recognized at the time of the 14th Amendment. They don't seem to be, nor was the right to sexual intimacy. Many state laws at the time, and I don't know of anybody striking them down, forbade any kind of sodomy. So what about those? Did these rights survive, or did they disappear, regardless of whether you put them under due process or under privileges and immunities?
Yeah, I mean, I think it would be case by case. Most states prohibit unreasonable seizure. I mean, sterilization seemed like a very extreme seizure, or cruel and unusual punishment, or that sort of thing. So, but I think it would be case by case, and that's. I think Luxembourg can be a bit constricting, which is why I favor privileges or immunities, which suggests some sort of evolving standard over time, and I'm not sure the due process clause does.
But as I said earlier, sometimes judges have to judge, hence the title. And I stole that from Judge Willett, who's now on the Fifth Circuit, by the way. These are going to be hard questions sometimes. And you're going to have to do a traditional text history and tradition analysis. I don't think Glucksberg is the appropriate framework, because as I said, I think it artificially takes you to such a specific, you can always craft any right. Like for example, if you had to do that with the freedom of speech, you could totally eliminate the freedom of speech. It's like, do you have the right to speak on a Tuesday to Joe? Like, I just don't see that in the Constitution. Where is that written in the Constitution? Did you have a right to speak to Joe on Tuesday about pizza? Right? Like, that's just not, if you're defining rights at that level of generality, then a clever jurist can always just write rights out of the Constitution. But I do admit that it does take some work. It does take some work to get that level right. So,
Audience questions?
A lot of the takeaway from the last portion of the panel seems to be that getting rid of substantive due process would be strong medicine for a lot of people. But given what we saw after Dobbs, when many states rushed to protect abortion much more fervently than they had before, would that alleviate some of the stress of if we did overturn substantive due process? Because most of the rights that are being discussed here, interracial marriage, forced sterilization, I would imagine would be like universally recodified in the statute code. So like, does that somewhat alleviate the issue there in your opinion? Any of your opinions?
I mean, but the whole point of having a written constitution is that rights aren't subject to majority vote. And I would say the right that wouldn't be protected, unfortunately, is probably things like private property rights. I mean, John Adams recognized that of all the rights to be protected, private property is probably the one you have to make constitutionally protected, because people will always vote to take something without paying for it. People will always vote to restrict their neighbor's property in ways that they wouldn't appreciate. And so when it comes to things like private property rights, economic liberty, right now, almost the only protection they get is substantive due process or the privileges or immunities clause. So if those things disappear, I don't think that they would get the legislative protection that you're talking about. But some of the other ones might. I just don't think that that's an answer to whether or not something's in the text of the Constitution or not.
Yeah, I agree with that.
Another question?
It seems like you both agree that there should be some like fundamental rights that are protected by substantive due process, because otherwise, like torture against non-citizens would be permitted constitutionally. What do you think should be the limiting condition for how we expand these like substantive rights? And so, how do you prevent a situation where like the conservative court during Lochner just passes all these overrules all these like minimum wage laws, or like more liberal court during like Warren, and after that like allowed for Griswold and Roe? Like, what should be the limiting condition in your opinion?
Well, I mean, I think Lochner was probably rightly decided and poorly written. But I think you have to base it somewhere in the tradition. For example, if it's a right that has never existed in any treatise or any case, and it's not in Cook, and it's not in Blackstone, and it's not in the radical Republican writings, then it's probably not a right that was understood to be a liberty right protected at the time. You're going to have to make an argument, and that's the limiting principle. I think that's the best way to do it, is just do the same thing we would do with any other text, and we try and understand what the original public meaning was. And if it's not protective enough, then we amend the Constitution to add greater protections. But things like torture, things like just killing people, I think that those sorts of things would have been constitutionally protected in 1868.
Yeah, I mean, this has come up a couple times now, so I want to put this to bed. I don't think torturing non-citizens would be permitted even under revived Privileges or Immunities Clause. You do have the Due Process Clause, whatever it means. You do have equal protection. You do have incorporation. The Eighth Amendment applies to all, not just citizens.
But none of it's incorporated through the Privileges or Immunities Clause.
It would, right?
No, the Privileges or Immunities Clause only applies to citizens. So if the Eighth Amendment is incorporated through the Privileges or Immunities Clause, then it doesn't apply to non-citizens.
Seems like equal protection could get you there.
Maybe.
That's for everyone.
Yeah.
So
I mean, I'm not sure there's an original understanding argument that treating aliens are people who are not citizens different from citizens violates equal protection. Under the court's current doctrine states, those are suspect classifications, but I'm not sure there's a good originalist argument for that.
Yeah.
Myself.
Yeah. I think that's probably right. If you don't have a base level substantive due process protection, incorporation's not going to get you there.
A question about the consensus test that you all described. I think that you described and you also discussed. I can recall you dubbed it a version of living constitutionalism. I think another version of it that might be possible is sort of the Randy Barnett version, which is that you have a floor of rights at 1868, but then there could be some sort of consensus over the years that would have to be sort of both like a supermajority of states, for example, and then in time as well, so like a generation or two, that would then allow to expand above that floor. That's kind of another maybe more middle ground consensus test, and I wanted to see if either of you would agree with some version of that.
Yeah, no, I think it's a lot of overlap with my views, as I said a few times. It's underdeveloped, this theory, and I have my own very tentative theory that maybe tiers of scrutiny could apply, like the number of states that, or the length of time, maybe there's scrutiny, level of scrutiny there, but yeah, no, I agree with that.
Yeah, I hate tiers of scrutiny so much. With the burning fire of 1,000 dying suns, I hate tiers of scrutiny. But I would say that you do see something similar with the way that we do the substantive due process analysis with property. So there's a base level of property that's understood, like the state can't just declare something not to be property that historically was property, like at common law, but the state can create additional private property rights and then can't take them without due process. So I could see something similar where you have some sort of doctrine where there are certain things that are recognized rights within a state, and then you would have something that means that you can't deprive those rights either. I'd have to think about it a little bit more, though. That's not ordinarily how we do it, but the closest analog would be the property jurisprudence.
Yeah, Mr. Skorup. So, I mean, the Declaration says this, but at the founding, at least we're taught that a lot of these guys had an understanding of law as where it's kind of Lockean. We essentially enter into sort of a compact form of government in order to help protect our natural rights, and government's, real main purpose is to help protect those. And with that background in mind, why isn't tailoring at some level part of sort of the requirements for government action or like process of law? Where wherever the government's doing, there has to be like, it has to be tied to, in some way, to what their stated purpose is. So whatever law they pass, it has to do that. And that's basically what we're doing in substantive due process. You have fundamental rights. You can violate them if it's, narrowly tailored and so on. Whatever level of tailoring you're dealing with. Why isn't that part of process of law, given that general background understanding of government that existed at the time?
My response would be, again, I think the proof is in the pudding on substantive process. They've tried to tailor for 150 years, and again, you have this whipsaw effect, and I don't think anyone is pleased with the state of the law. I see the benefit of moving towards privileges or immunities. You have a somewhat blank slate, you can escape a lot of the baggage that's developed over time in substantive due process.
It couldn't have been a new court in 50 years if we start doing privileged immunities now, like just kind of seesaw and do the same thing. Privileged immunities.
Sorry, could you say that again?
Let's say court abolishes all substantive due process rights now, puts them in privileged immunities, whatever they think the correct number of rights are. 50 years from now, Dems get 6 administrations in a row and they replace the entire court. They're still doing privileged immunities clause. Couldn't they just change everything it is? How do you get what all
I favor some, modified version of Luxembourg where you look at history and tradition and ordered liberty plus this consensus factor by looking at what states recognize.
I think that there was that tailoring in cases like Yates versus Milwaukee, and there was that tailoring in the late 19th century in a lot of these cases. That's exactly what they were doing. They were saying, what's the evidence in the record? You claim that it's nuisance abatement or whatever. You can't declare something's a nuisance when it's not so in fact, so show me that it's a nuisance. Show me, for the longest time, the court said that the scope of the police power was, I'm going to screw up the Latin, like sicutere non leatus, I can't say the rest of it, but the maxim was don't use your property to harm others, right? And that was the principle of the police power, and it wasn't that complicated until you had a lot of progressives that wanted to do a bunch of economic regulation that wasn't permitted under that standard. And then later you had a bunch of folks who wanted to do a lot of social regulation that wasn't recognized under that. And so, yeah.
So it does sound to me like you want to just throw out all the state laws that are protective of people who are in economically poor positions to bargain, right? Because they all, as Lochner said, they interfere with the freedom of contract.
Well, I think the court in Lochner, that same court had just upheld a regulation on iron smelting because the evidence in the record showed that it was actually a dangerous condition. What the court said in Lochner is you don't get to pretend that baking bread is a hazard. And so there you had a clearly protectionist law, a law that was clearly designed to punish immigrant bakers, to prop up pre-existing bakers. And then the court looked through that and said there's no evidence in the record.
So for somebody who doesn't like tiers of scrutiny, that sounds an awful lot like either intermediate or strict scrutiny.
Well, I think what it's closer to is saying whether or not something is within the police power. And whether or not you just have to say, because you don't have a right to use your property in a way that harms others. And since dating back to the common law, courts have been able to determine whether or not something's a nuisance by looking at the record. And they can do the same thing with legislation. And so I don't think it's tiers of scrutiny. You're not saying is it an important interest or a less important interest, and then we're going to balance it against something. You're just saying you don't have the right to do things that harm people. Is this something that harms people?
No, but what intermediate scrutiny does is it requires a factual basis in support of your asserted justification, whereas rational basis review does not. And it sounds to me like what you want is a court to insist on a factual basis, which to me sounds an awful lot like intermediate scrutiny. But
yeah, well, okay, I have to just flex a little bit though. I just won a case in the Fifth Circuit a while back that said you do get evidence in rational basis cases. So
I'm glad you said the Fifth Circuit.
So, at the beginning of this evening, you cited Calder against Bolin, Justice Chase's
Yeah.
famous statement that, it's not even a law if the legislature contravenes these natural principles. And yet, in a concurrence in judgment, Justice Iredell points out that, not so fast, Justice Chase. It's something of which our history and tradition has actually mixed results on. And now that we have a written constitution, we are limited by the text. We're not freewheeling common law judges anymore. And what's this due process right you're invoking when the text of the Constitution alone satisfies our judgment?
Yeah, Justice Iredell was in dissent a lot on the early court,
But
but
concurrence in
yeah,
judgment.
in concurrence, and no, I'm saying in other cases he was in dissent quite a bit. He was also in dissent in Chisholm, and I guess he got proven right by the 11th Amendment. Though I do think that John Jay's interpretation about sovereign immunity was correct, but different case. I think by 1833, I think you have a much closer case in 1795 and 1798 on these principles. I think by 1833, Joseph Story had pointed out that the majority position amongst state jurists interpreting their state constitutions was closer to Calder versus Bull, closer to Justice Chase's opinion. And I think by 1868, it's the overwhelming majority. In fact, by 1868, well over 50% of state courts had interpreted their state constitutions to do something closer to Justice Chase's opinion. So yes, if you're just looking at Iredell versus Chase, there is a dispute. There's always dissenting opinions when it comes to these things in law, but I think you look at the majority opinion, by the time 1868 rolls around, the majority is in favor of substantive due process.
So does the Fifth Amendment due process clause have a different meaning than the 14th Amendment due process clause?
That's a much harder question. I think that's a much harder question. I think it could. I think you would look at what it was understood to mean at the time. I'd like to think that it does have substantive due process, but I haven't done the work on that, so I just can't speak on it.
Another.
Yeah.
So, in the Constitution, a lot of rights are very affirmatively outlined. Positive rights less so than the negative rights, but they are outlined in the Constitution. My question is, from a normative perspective, why are we trying to strain readings of the Due Process Clause? Why not dispel of it altogether and allow states to utilize their policing power? If something is truly commonly understood to be bad, would democracy not be the most effective adjudicator of proof of the pudding of that being the case? If sodomy laws are truly so horrible, then surely no states will pass them.
I don't think historically it's true that if things are horrible, no states will pass
I'm
them.
saying right now. More common understanding right now.
Yeah, well, I don't think that common understandings determine rights. But again, this goes back to whether or not you take, again, you're looking at what, it's not a question of whether it's wise to have substantive due process. The question is whether or not the people who wrote the 14th Amendment believed that it provided for substantive due process. And to that question, you have to look at what people were writing at the time. And the majority of people writing at the time believed that it did, for better or worse. Maybe it was dumb for them to do it. I don't think so. But the question as an originalist, as someone who's trying to say what the law is, as someone in the Federalist Society, you're trying to say what the law is, and there you're looking at what they understood at the time. And they weren't legal positivists. So.
Yeah, to defend Mr. Skarup's point a little bit about like what you classify as living constitutionalism, isn't the due process clause in many ways a very open textured provision? Right, it requires like I think from your analysis, it requires the Congress, the legislature, right, of a state or the city to do their homework to show that like we're doing this for a good reason, like Lochner-esque, we're doing this for a good reason. We're not being discriminatory. There's no evil eye, evil hand, and that a lot of what we classify as what is a right, what's a reasonable regulation of that right, I think is subject to some evolution. Right, so like I think Professor Burnett would call like the interpretation of due process. Then we construe our interpretation in a sense that will allow for some flexibility, but at the same time sticks to the spirit of the due process clause. So that to me it's not living constitutionalism. It's just a form of originalism that necessitates some level of flexibility and evolution in society.
I don't think you're doing originalism at that point. And I think that the answer that I would give is and originalism is just the way that we ordinarily read texts. So if I send you a text message, or I'll put it this way, let's say that you have a contract, and this came up in the Texas Supreme Court a couple of years ago. Let's say you have a contract from 1920, and the contract of 1920 is talking about, say, oil and gas leases. Well, the meaning of the terms of that contract don't evolve over time. You're going to go back and you're going to look at the dictionaries and try and understand what was meant by that contract in 1920, and the Constitution isn't different. So maybe I'm misunderstanding your question.
Yeah, that goes to interpretation.
Yeah.
Right, whether a judge today is looking at, like, let's just say, there's the Congress passes a statute, court's looking at a statute that the legislature passes, says is that someone who parks in the wrong spot gets executed or something like so extreme. The court's never going to look back at what happened in 1868 to figure out whether a parking spot, law in that sense would have been valid, because there could be, this is a problem with brewing as well. There might not be a lot of history in that realm, so they have to use their reason to make a rule that's consistent with the spirit of the due process clause, which has a fixed meaning, but the implementation is subject to evolution.
Well, you would have to figure out what it means, and then you would apply it to modern facts. And I think,
Okay.
and so I think a really good example of this, and I don't want to dominate this conversation, but I'm nerding out on this. It's really fun. So I think a great example of this would be when you're looking at, say, the Carpenter case. So this is a Fourth Amendment case, and you're talking about storing data on servers. And there's this great moment in the oral argument there where they're talking about the third-party doctrine. They're like, well, you don't own the servers, a third party owns the servers, and so your data's on the server, so doesn't that mean the Fourth Amendment doesn't apply? And Justice Gorsuch says, why isn't this just the writs of assistance cases? In the writs of assistance cases, all of the stuff was held in a third-party warehouse, but that didn't mean that you didn't have an interest in your property in that third-party warehouse. And so you're just drawing analogies, and I think you can do that to make sure, but you have to first figure out what principle is embodied with the text.
Yeah.
If we're going with the Glucksberg plus consensus framework, and we're also reviving dead amendments, would the 10th Amendment's rights reserved for the states not reserved to one state the right to be stubborn and hold out against the other 49 and refusing to accept some element of modernity?
Are you saying it under my
So
test?
under your
Yeah,
test,
so
yeah.
like-
So if you have 49 state consensus, and I was just looking up the word consensus recently to figure out whether it means every single person agrees or whether it means in general they agree. And I saw there's two different answers to that question that AI gave me.
As long as it
So,
doesn't get
take your consensus test, whatever it is, if you have a broad agreement, but, one or two or three states hold out,
Yeah.
why don't they get to?
Yeah, I mean, I think ultimately you have to recognize as a universal. I use that term loosely, but a universal policy. I mean, even amending the Constitution does not require unanimity. So I think as you get closer to a supra majority, certainly 49. If you need 38 states to amend the Constitution. So
Anything over that, you think? Would be
Yeah, I mean,
enough to establish
again,
one of your new rights?
These are very tentative ideas, but I think as you get closer to 38 states, if they've done something, I think yeah, it starts to look like a national right that everyone is entitled to.
So are there others? I just want to interject one, so we still have a little bit of time, which is, what do you do about if you think the original meaning of something is other than what the court has decided? Do you apply stare decisis to that, or do you just blow off stare decisis as Justice Thomas has? Because I think that's part of the critical debate about what to do with these, what I would call the modern, the Warren Court era rights that I don't think hold up under Glucksberg. Now, I might not apply Glucksberg, but even if I did, I would still move on to stare decisis. And what do you do about stare decisis when, originalism, you think you have the best of the argument, you recognize there's another side of the argument? What does stare decisis do for either one of you? Does it matter?
Yeah, I agree. It certainly matters. I think it's ultimately a pragmatic way of approaching it. I mean, you might not be surprised to learn someone who works for Clark Neely at Cato and judicial engagement. So no, I do think revisiting and overruling is the job of judges when something is plainly wrong.
Yeah, so I think, so Justice Thomas wrote on this once, and Judge Ho has written on it a couple of times. I think first it would matter where you're at in the courts, right? So certainly, the Fifth Circuit, Sixth Circuit, Ninth Circuit is going to be bound by bad Supreme Court precedent. They don't have a duty to expand that precedent, of course, if it's non-originalist. You should not expand those precedents. But if you're at the Supreme Court, I think Justice Thomas's approach has been that if it's a close question, and it was decided very close to ratification, even if you think that maybe it was wrongly decided, you're going to defer to that precedent. But then after that, if you're 40, 50 years post-ratification and something's just wrong, you just apply the original public meaning. I think that's, and in equity you can do things about reliance interest and things like that, but at the end of the day, the job of the court is to uphold and apply the Constitution of the United States. The job of every lawyer when you take an oath is to uphold and defend the Constitution of the United States. Even if sometimes my government attorneys on the other side don't remember that. The purpose is to uphold the Constitution of the United States. It's unfair shot. I like my government attorneys.
So somebody like Justice Kavanaugh might say the original meaning of the Constitution in Article 3 is to carry forward strong principles from Blackstone about stare decisis, and only if decisions were sort of, as he would put it, egregiously wrong, would you overrule them. And so, I guess that's the other side of the originalist argument.
Yeah, I think people disagree on it. Justice Kavanaugh disagrees with me on this.
Other questions from, I think we have time for one or two more.
Let's say, miracle upon miracle, the Supreme Court gets rid of the Erie Doctrine and federal common law returns. Do you think that federal common law can develop in such a way as to protect individual rights against state action? Or do you think that substantive due process or the Privileges or Immunities Clause really are the only ways to protect individual rights against state action? Because those two depend on the Constitution. Federal common law openly does not.
So I have no idea.
I'm gonna dodge that one as well.
Try it?
Yeah.
I'm so out of my depth.
So if it doesn't, Will Boat say that either due process or the Privileges and Immunities Clause or one or the other incorporates general common law?
Both.
Both, yeah. Okay. So is that where that question was coming from or no? Yeah. So I don't get that concept, I have to admit. So I'll have to read Will's writings on it. So far, it's not intuitive to me.
For Mr. Weldon, so do you think, it's basically Texas's rational basis standard where they actually have to look at the record and have a sort of factual judgment of what you think substantive due process entails? Or is it some level slightly higher than that?
So I think that the Texas and post-Patel, I think, has done a pretty good job articulating something like a working rational basis test. It is a deferential test. I think the one place that I would say that Patel didn't go far enough, I think I would go full back to Yates versus Milwaukee, where you had courts doing an independent. They didn't have to create justifications for the government. The government would have to affirmatively claim them in court. But other than that, I think you're pretty close. Texas does a really good job when it chooses to apply Patel.
This has been a great hypo, but scale of 1 to 5, with 5 being definitely, 1 being never. What's the chances this actually happens? Overruling.
When?
Substantive.
Yeah.
Now is 0.
Yeah. So
that, things can change.
I don't see it happening. I'm a Cubs fan though.
So the court just denied cert in a case attempting to overturn Obergefell. I don't think the court has a lot of appetite to completely jettison substantive due process. I think Justice Kavanaugh, because his views on precedent, wouldn't do it. I don't think Justice Roberts has any appetite for it. Really, the only person on the court that wants to do it is Justice Thomas. And I love Justice Thomas, but I don't think that he's going to convince his colleagues on that one.
So, just look at the way Dobbs was written.
Yeah.
The first part of the opinion was Glucksberg, let's just apply Glucksberg, but then you get to the point of where they're looking at precedent, and they say we don't want to overturn any of that precedent, so we're going to give you a distinction between all of the cases that most people in the country like, and the one that we think is different, and that's how we're going to decide the case ultimately, based on that distinction. So you wonder what the first part of the opinion is actually doing, because everything seems to be wrapped up for the justices who signed that opinion in the piece about precedent. And I just don't think you had anybody there who was eager to do anything other than what they did, which was to get rid of the one that they saw as different. And, it's no accident that you have Justice Thomas speaking for himself and no one else. I mean, he didn't even get Justice Gorsuch for that, who I think is closest to Justice Thomas in his approach to stare decisis. And so there you have it.
Just know it looks a little bit like a state consensus test they're applying.
It does. Well, that was the O'Connor Kennedy. If you want to go back to them, it was the aberrant state law rule, I used to call it. So, if you had an aberrant state law, it was going to be struck down on some ground or another. I'm not saying due process. It could have been anything. Pick a constitutional provision that was going to go one way or the other if it was an aberrant state law.
I will say this in defense of the distinction that Justice Alito draws in Dobbs, because it fits with my idea earlier when I was talking about the scope of the police power being sequitare, non-laius, don't harm your neighbors. I think the point that he made was abortion was the only one of the rights recognized under the due process clause that involved hurting another person. And so I think there's a certain overlap there, even if unintentional.
Interesting point.
I think that's all the time we have. Yeah. One more question, sorry.
We got one.
If we were to move all these substantive rights from the substantive due process clause to the privileges and immunities clause, what practical benefits would that have for us? I guess compensate for the potential consequence of depriving non-citizens of those rights.
Yeah.
This is the person you wanted to
Yeah.
ask that question.
Yeah,
Oh, yeah.
Yeah, I mean, I see a few benefits. As I mentioned, I think you escape, the right and left distrust substantive process for different reasons, different eras in history. I think you can escape some of that baggage. You have a clean slate with privileges or immunities clause. And if you look at the debates about the 14th Amendment, they're hard copy. I would say it's a draw on which which they believe would be operative. I think you can pick and choose the legislative history you would like. But all that to say, I think privileges or immunities offers a cleaner slate. Again, I think it gives you more room to have this kind of Glucksberg plus test, which they seem to be essentially using anyways. I'm trying to think if there's other benefits. I think textually it's a little sronger than some due process, so those are the benefits as I see it.
Wouldn't we still have the same,
Sorry, one more. And also, we were left with this legacy from Parrish where economic rights are relegated to second-class rights. And privileges or immunities allows you to look anew at this and not relegate economic rights to a second-class citizen.
Thank you, everyone.
That's a good question. Thank you.
The worst thing ever.
I think some of them survive.
That's not really what I was.